Good afternoon, Judge Stevens. We have everybody available. All of the parties are present, so whenever you're ready to start, we can get it started.
Okay, I am ready. This is case 20-000-169, Election Integrity Fund and Glenn Sitek versus Jocelyn Benson in her official capacity as Secretary of State. If you would please invite counsel into the hearing room. I'm seeing a blank screen, but I can hear someone.
Your Honor, this is Mr. Grime on behalf of EIF and Mr. Sitek. Can you hear and see me?
I can hear and see you now.
Very good. I'm going to reach over and close a blind because there's quite a glare. It looks like a Baroque painting here on my screen. So just 1 second.
While he's doing that, Your Honor, Ian Northen here also on behalf of the plaintiffs, although Mr. Grime will be making our arguments today.
Good afternoon, Your Honor. Heather Meingast on behalf of Secretary Benson.
Again, this is case number 20-169, Election Integrity Fund and Glenn Sitek versus Jocelyn Benson. Pending before the court is a motion for preliminary injunction, a response to the motion in opposition to the preliminary injunction, a motion to dismiss. Additionally, a motion for summary disposition was filed on 10/9. The court did not suspend the ordinary rules for the motion for summary disposition, so therefore it is at this point not before the court. If you could please proceed on the motion for preliminary injunction, please.
Thank you, Your Honor. What I would have for you today is just some oral argument. Under your rules, there is not a chance for a reply. And so some of what I will be saying here will be new and something we normally would put into a reply brief. But I'm just going to make basically 2 points on the 2 issues that I think are dispositive on the preliminary injunction motion. The first of those points, Your Honor, is that this is essentially an issue of statutory interpretation. You saw a lot of briefing about interpretations of the Michigan Constitution. We're happy to address those. You also saw arguments about the scope of the Secretary of State's generalized authority under other parts of Chapter 168. However, if you closely read the Secretary's briefing, it seems apparent that the question ultimately comes down to what does the absentee ballot and absentee ballot application statute require? And frankly, the parties seem to be spending a lot of time talking about the question of what is a signature and what does it mean under the statute. And so on this first question of what a signature is, I have 3 points, Your Honor. And then the second thing I'll cover after I do this is Laches. I'll take just a few moments. So, Your Honor, there are really 3 main reasons that the signature that is required to submit an absentee ballot application must really be a signature. It must be something affixed by the person who is making the application. It can't be a pre-recorded digitized signature that might have been made by that person, if at all, 2 or 4 or 6 or even 8 years ago that resides somewhere else on a database. Now, first of all, the legislature showed very clearly, Your Honor, that it knew the difference between a digitized signature and a signature. In fact, if you look at the plain text of section 168.761, subsection 2, it tells you exactly what the two types of signatures at issue here are with an application. And I'll quote it. It says, the qualified voter file must be used to determine the genuineness of a signature on an application or an absent voter ballot. Signature comparisons must be made with the digitized signature in the qualified voter file. If the qualified voter file does not contain a digitized signature of an elector or is not accessible to the clerk, the city or township clerk shall compare the signature appearing on the application for an absent voter ballot to the signature contained on the master card. That would probably look better if it were printed out. I know I just read a lot of words, but basically, Your Honor, when the legislature is talking about an actual signature that someone signs on paper, either on the application or on the voter card, it uses the term signature. When it wants to talk about something that's appearing in a state database that's digitized, that was fixed a long time ago, it says digitized signature. And that's very, very clear. The legislature used the word digitized signature when it needed to. Now, why is that important? We have to ask ourselves, why was a signature even required here? Well, the section I read just told you that. It's to determine whether the underlying signature on the application is genuine. Why do we want to know whether it's genuine? Well, we want to know whether that person actually made the application. And so the purpose of this is not to sort of be able to say, oh, we have a signature somewhere. It's not symbolic. It's actually to try to test the authenticity of the application. Now, the Secretary of State has what they put forth as an answer to this. They say, okay, in the regular course, a paper application comes in, it's got a signature. You check that against the qualified voter file. And that's what the statute we just read says. That's what you have to do. They say nothing has really changed here. In this case, with an online application, you compare the quote signature on the application, which is not really a signature, it's the motor vehicle database signature. You compare that to the qualified voter file. But we have to ask ourselves, what's the point? What are we really learning if we are comparing the motor vehicle database signature to the qualified voter file signature? What if they don't match? What would that tell us? It might tell us that the qualified voter file signature is wrong. It might tell us that the motor vehicle database signature is wrong. That would be interesting. I don't know which would take precedence there. Maybe one is real and one is not. But regardless, it tells us nothing about the application. We would know nothing about the application. Two other people could have fraudulently signed those other signatures, and then now the real person comes along with an online application, and they're caught in the middle. In fact, why wouldn't we just do a purge? Why wouldn't we just check right now all of the signatures in the motor vehicle database and all of the signatures in the qualified voter file? It doesn't really bear any relationship to the fact that there's an online application. Why shouldn't we just check those anyway? So the point is, the reason we would check the signature on an application is to make sure that it's genuine, make sure the application is really done. If we're comparing two other digital signatures existing somewhere else with the state, we're learning not a single thing about that application. We're learning nothing whatsoever. And so the whole idea of why you would have a signature and why you would check its quote genuineness disappears if you use some pre-existing digital signature and check it against another pre-existing digital signature. There's a second sub-point now on that, and that's this. Frequently, the two digitized signatures that are being checked on this online process will simply be the exact same signature, not just signed by the same hand. No, they'll be the exact same digital signature because under Michigan law, the way that the qualified voter file is populated, the way those signatures get in there are by the act of people going and applying for a driver's license or renewing their license. Whenever that happens, that gets filtered down and put into the qualified voter file. So again, it would be interesting to compare those two sets of signatures and see whether there are really differences. And if there are, it'd be troubling. They're probably identical in most cases. But regardless of the outcome of that exercise, it tells us nothing whatsoever, Your Honor, about the application. And so that was our second point, is that not only does the Secretary's interpretation of what the signature requirement is violate the plain text of the statute, but it eviscerates the whole reason for requiring a signature and testing it for genuineness. But there's even a final problem, a third problem. And I think maybe this is the biggest issue of all. So there's a very important admission at page 19, Your Honor, of the Secretary of State's brief. On page 19, they try to tell us, but the point they think they're making at that point is that we can really be sure that even with this online system, all will be well because we take, wet or quote, handwritten signatures, which the Secretary treats as terms of art that the legislature had to have used. The Secretary says, oh, don't worry, those are provided for on the ballot itself in section 168.761. Don't worry, the language there tells us that at least the signature on the ballot has to be wet or handwritten. Okay, so if you look at 168.761 and you compare the language there to the language in 168.759, which the Secretary says allows digitized signatures, they're the same. There's nothing in 168.761 that tells you that this has to be, quote, wet or handwritten, but the others don't. And so, in fact, if you compare the two forms, because in both statutes, Your Honor, which I know you've had some of these, I know you've had a lot of cases about this recently, and you may have looked at these two statutes, you'll see the legislature actually put the form it wants the Secretary to use and the clerks to use in both statutes. And both times they have an instruction that says sign here, and then a line, and then it says signature. That appears in both the application form and on the ballot envelope form. And both times it instructs voters, it has instructions, and it says you have to sign this. And it says both times that they have to be printed in substantially the following form, and both times it says the above form must be signed or your vote will not be counted. And so, Your Honor, I think what the Secretary maybe realized in making this argument was, well, wait a second, we've got a problem here, because if our argument is correct about the ballot application, then necessarily we should also be able to take digitized signatures on the ballot itself. And so, Your Honor, if the Secretary's argument is correct, then what you could do is you could get online. There'd be nothing wrong with having a system where you've got a driver's license, you got the last four digits of a social security number, and you can go on, you can apply online, you can get the ballot back online, and then you can fill out the ballot online and again sign by requesting that, let's just use the voter data or the motor vehicle database. We'll just use that signature because again, it just says signed. And we're going to require that the General Assembly do something like say, you've got to use a wet or a handwritten signature. So, Your Honor, for those three reasons, the Secretary of State's argument just cannot hold water. If what she's arguing is correct, then we can go all the way with online. That's not what the legislature said. So that's the first point I want to raise. Your Honor, I wasn't sure. Was I detecting that you had a question before I move on to my next point?
If I had a question, you know.
Okay, very good.
Okay.
On Zoom, sometimes you can't tell, it lights up and it looks like someone's trying to say something. Okay, my next argument is on Laches, and there's more of a history about the back and forth between the parties on this that I won't go into, about counsel's communications before the motion was filed. But I think we can resolve this issue by looking at one point. I'm sorry, I'm trying to, and the key point is this, Your Honor, prejudice. Laches requires a showing of prejudice. And in this point, in this case, the Secretary of State would simply be doing the same thing now that they would be doing had we been able to have this hearing a month ago or 6 weeks ago. All they have to do is simply remove the functionality on their online system that allows someone to go on and click through and borrow their signature. Remember, and this is in the affidavit, paragraph 7 of the affidavit that the Secretary of State attached, they have always had a system where you could go on, fill out your application, and then what you would do is you just would simply print it off and either fax it or take a picture of it and email it in. They've always had that system. You could actually do that today still if you wanted to do it. So this is not about reimagining the entire way that elections are run. This is simply going back to the system that they had only a few months ago. That's all we're asking that they do. And there's no reason why that can't be done in a day. The signature, the instructions to the clerks are not a problem. Remember, they make a big point that this is really the same system they've always had. The clerks are still being told to look at the signature on the ballot, or I'm sorry, on the application and compare it to the qualified voter file. They're already being told to do that. In fact, it's trickier under the revised system that was just implemented because they've got to go borrow that digitized signature from somewhere else. And in many cases, it's the exact same digitized signature. So all they're doing is using for these ballots the same process they use for all the other ballot applications. So not a lot is being asked here of the Secretary of State. Even if there were a delay, and I won't go into that issue here, even if there were a delay, the delay itself has not caused any problem. They have to be doing the same few limited steps, on Monday that they would have been doing 2 Mondays ago or 3 Mondays ago. So Laches, Your Honor, can't apply. I'm happy to answer other questions that you may have or address other arguments that normally would be in a reply, but I can't get to everything here. But Your Honor, I think those are the 2 main points, and we ask that you enter the injunction in our favor. Thank you.
Thank you. Ms. Mindguest?
Good afternoon, Heather Mindguest on behalf of the state. Your Honor, I think I'm going to start with Laches because I think that's our principal argument here, and I think it's well taken. There is a delay here, and there is prejudice. We rolled out the online platform on June 12th. It was used through August. The Secretary of State has advertised, has publicly announced and advocated for the use of this online process throughout the summer. People began using the online process to apply for November, even in June. You could click a box and say, I want to be on the absent voter list for, to receive a ballot for November when you did it earlier this year. So we've had people using this process since June. They've been able to use the process to apply online for a ballot, even for November, since that time, and even increasingly so, obviously, since the middle of summer and towards the fall now. So we've had this up and running for quite a while. It was used in August, as plaintiffs acknowledged, and we haven't had any reports of trouble. And we've had thousands, as we put in the affidavit from Dr. Rader, we've had 75,000, 74,000, at least 74,000 people use this process to sign up for November. And from our perspective, we anticipate there are any thousands of numbers of people still interested in using this process right now to apply for an AV ballot. So, they didn't file this complaint so knowing all that, this complaint wasn't filed until August 24th. There was no service until 9/18. I think Plaintiffs' Counsel reached out to me somewhere in the interim of that saying, hey, would you accept, email service on behalf of the Secretary? And we're like, no, you have to serve pursuant to the court rules for service, and we ultimately got served on the 18th. They didn't file the motion for preliminary injunction until the 25th. And here we are today. We're about, 18 days from the election. And the online portal itself is going to be closed as of October 30th. So we've got 14 days window left for the use of this platform. And the request for the injunction, as I read it, was, well, modify the process to somehow let the voter use the online application, but add a wet signature or a contemporaneous fresh signature. We can't do that in 14 days. I mean, we couldn't do that in time to have the process available for use before it's going to close on the 30th.
Why?
So the alternative, did you speak?
I said, why?
Why couldn't we fix that? Because the office explored, essentially what we'd have to do is get software. You would have to modify, we would have to change the process to use some kind of software that would electronically allow the voter to provide a signature at the time of applying. Now, the department, MDOS, has looked into doing that. We haven't done, they weren't able to do that right now, and it's not something that we can, purchase, implement, and do in the time remaining. Now, could there be some cobbled together?
Pardon me, when your colleague said that you could simply disable a function on the online platform, he was incorrect?
I understand them to be saying modify the online platform to somehow include a contemporaneous, fresh written signature from the voter.
I understood him to say merely disable the ability to import the signature. So,
well, then it wouldn't work. We have to just shut it down.
I understand that, again, he could be wrong. He suggested that you could disable that function. I don't know from whence he got that information, and that the individuals would still be able to download the application and fax it into wherever you fax things into.
So I think what counsel was referring to, and I welcome him, he can jump in, but I believe he's making the point that you can print out from the website an application for an AV ballot. It's online. You could, it might even be fillable online. You could fill that out, you could print it out, and then you could sign it and you could mail it in or fax it in or email it in, like take a picture and email it in or scan it and email it in.
That is exactly what he said.
Right. So the online portal, the platform doesn't work that way. It's all online. You check boxes and fill in bubbles.
Okay.
Essentially,
so what you're telling me is that if I grant him the relief he's requested, you would shut down the online portal, but there would still be online access to an application. Is that correct?
We would have to shut down the online platform, but people can always fill out an application and send it in, either by mail, or you can, send it in by fax or email to clerks.
I think that's
so you
yes.
can still, yes. It's just not the same. It's not
I'm very clear it's not the same. I'm very clear.
Right. Okay. Well,
So let me understand then. What is the nature of the prejudice you would have me find?
The prejudice, Your Honor, is first that we've been advocating, we've been using this system for 5 months or 4 months, right? It's been out there, it's been used thousands of times. As far as we know, thousands of people are planning to use it in the next 2 weeks as a convenient and fast way of applying for an AV ballot. We believe the process is consistent with the election law. It doesn't violate election law. It's consistent with our constitutional mandate to implement no reason AV voting in Michigan. We've had this process up. It's been running. It's been used. And we've advocated for use. And we would have to shut it down. I mean, we could put a disclaimer on the website, but then we'd have to communicate, let people know, sorry, you can't use this process anymore. Can we do that in the same, to combat the effects of all of our public advocation for the use of this process over the last several months? So I think that is our prejudice, and it's also prejudicial to the voters, who may be waiting or seeking to use this convenient online platform to request an AV ballot.
Okay.
And the prejudice would simply be, look, they've come in here late to change this process with 14 days left. I mean, is that they haven't really explained why they didn't file on August 5th or earlier than that. If the trouble was discovered at the August primary, then where were they, shortly after that? It's about the timing of all this and the process that we've developed, and a process that we believe is both, consistent with the statutes and with the Constitution.
Okay. Anything else?
All right. Well, with respect to sort of their merits argument on the applicant using this online platform, I mean, the relevant statute is 759, which talks about how you apply. They seem to admit, or at least not contest, that the online platform or the online form, the way you would do it, is a written request. And so the question is, what does it mean in 759 in the request section to sign a voter's signature? What does that mean? It certainly means a fresh, contemporaneous, handwritten signature in wet ink on an application that I might go take to my clerk and hand over. It certainly means that. But there's nothing in the statute that says it doesn't also mean a signature that we've already captured. And I just want to explain that there's only one signature here. The QBF and the driver file speak to each other. So the signatures, there's only one signature that would be used in most cases. There may be a secondary signature, but the driver file and the QBF speak to each other and they use the signatures. So there's not multiple signatures all over the place. So there might be a secondary signature on occasion for a person that's stored in, but there's not a driver file signature and a QBF signature. We've got the one signatures that's taken from the files that talk to each other. Because you can get the signature comes from either a voter transaction at the Secretary of State's office or from a driver file transaction. So that's how the signatures go in. So there's really one signature, and that's what we use. And so if you look at 759, it doesn't say that it can't be, that that's not a signature. That using the voter's signature that's already their handwritten signature stored in the QBF could not be used to sign the application when it goes to the clerk. And it's difficult to understand how this could be violative of the process when the legislature has set the QBF signature, or this digitized signature, as the gold standard. This is the signature that we compare everything to. Well, that's the gold standard, is what we're letting voters use to apply for an AV ballot. So we're already using sort of the gold standard of signatures. They're correct in that there is some element of redundancy, because when the clerk receives the online application, they'll print it out, it'll pop out, and it's going to have the QBF signature. So essentially what they're doing is they're going to look at that application and they're going to double check their information for the voter, including their signature. And of course they're going to match, right? The QBF signature and the signature they got on the application, unless there was some really random thing that happened. So, but again, that's the gold standard for the signature. And what we're talking about is applying for the AV ballot. We're not talking about the AV ballot itself, which of course, as council noted, does require an ink handwritten signature, because there is no online process or mechanism for doing online ballots right now. So obviously that does require the handwritten signature of the voter. At the end of the day, that process is really still the same. The clerk compares a wet signature on the AV ballot to the QBF signature. I mean, that's so, to the extent that the online application is being used to request a ballot, to the extent they have concerns, first of all, this concern about somehow that this process is more ripe for fraud than an ordinary application is not well taken at all, because you have to have a lot more information to go through the online portal than you and I have to do when we simply sign and fill out an application for vote on a paper. We're not putting in a driver's license number. We're not putting in our last 4 digits of our social. To fraudulently use the online portal, somebody would have to have a lot of information about a voter that you wouldn't have filling out a paper application. And in fact, the only incidence of fraud that we've had this year is from the ordinary paper application. And we charged that person. So the suggestion that the online portal is somehow more ripe for fraud, I don't think is well taken, and there's no evidence of that. And that would go to, then in a sense, undermines their whole irreparable harm argument, Your Honor, because the irreparable harm argument here is vote dilution because they're afraid there's going to be more fraudulent ballots and extra money spent on protecting against this possibility. But again, and so they're concerned that somehow there's going to be potentially more people fraudulently requesting AV ballots. I just don't see how that happens here, because at the end of the day, ballots are still compared to the qualified voter file signature. And the clerk does that before they go anywhere else to the absent voter counting boards or to the precincts. So at the end of the day, what's still happening is the traditional method, which is comparing the absent voter ballot, the signature on that, to the QVF. So it's not, this online process is not, if anything, it's a better, safer process or less prone potentially to fraudulent manipulation than the ordinary paper process. So I think that undermines, their claims of harm. And then with respect to, the balance of harms and the public interest, I think I've already kind of touched on it through the Laches argument. We've had this process out here. It's a process that enhances voting rights, and it would be detrimental at this time to shut down a process that's been available for months, that people have heard about, and that people have been using frequently to apply for a ballot in November. And so we would ask the court to deny the injunction.
You had also asked for dismissal, is that correct?
Well, Your Honor, here's why we did that. Because our answer was due at the same time that the brief was due. And so in lieu of answering, we incorporated a motion to dismiss in lieu of answering. And so that was the purpose for that.
Okay, anything finally, sir?
Your Honor, the only thing I would point out is I just want to highlight the significance of an admission that was made here, that in the Secretary's view, the motor file, vehicle file, and the QVF are, quote, talking to each other, and that it should usually be the same signature. I mean, if that's true, then it doesn't matter if it's the gold standard. A standard is, by definition, something you use to measure against something else. But I mean, everything is the gold standard if you're just comparing it to itself. The whole point was to compare it to the signature that was being made at the time to see whether it's authentic or not, or genuine. And so if you already know they're going to match because they're the same thing in the file, it seems to defeat the purpose. The only other thing I would say is there's been argument in the brief, and again here today, it seems to suggest that we have to prove fraud or show that fraud may be occurring using this system. And although that was one basis for EIF's organizational standing, the other issue here is that, in Michigan at least, there's a longstanding principle that if you are seeking mandamus relief, which we are here in this case, if you go to our prayer for relief and our complaint, along with injunctive relief, and you are doing this in an election case, your voters who want to enforce the election laws can do that without coming out and saying, okay, look, we've got 23 people who have so far committed fraud using this online system. Instead, you are enforcing the public interest in having the statutes followed. And I understand we differ on what the statutes mean, but that is the interest that we're trying to advance here, along with our organizational interest as well. And so, Your Honor, I think for all those reasons, we would ask that in this final period here, these final 14 days, that the Secretary of State revert to her system that she was using for most of the time up until about 4 months ago. People have many ways to get their applications in, but the one way they shouldn't do it is by borrowing their motor vehicle signature. Thank you, Your Honor.
Okay. Thank you. The case will be submitted. You will get a response early next week. Thank you.
Thank you.